Today is the last day in which to enter a plea. That is not to put any pressure on a defendant. It's to put the pressure on the attorneys and hold their feet to the fire to make sure that they are the ones that are processing the case appropriately. And so what I know today is they have done all their arm wrestling, arguing in the back rooms, in the alleyways, and they can't resolve it, which is fine. I don't care. You need to know, I need to know, my staff needs to know, witnesses need to know, potential jurors all need to know. We are going to trial. We all need to get juror subpoenas out. They all need to get witness subpoenas out. We need to have experts and witnesses and jurors all take time off from other jobs and duties to come here, which isn't at all a bad thing. It's all a good thing, but I just need to know before I set all those wheels in motion that there is no resolution. Okay. All right. Bond continues. I've never had an issue with Mr. Hunt. He's been here every single time. Therefore, bond continues. Now, I do recall that wasn't there a motion?
Well, it's my understanding that people have essentially withdrawn the request to introduce the evidence, thus rendering the motion moot.
Okay, and that piece of evidence was allegedly an image.
Correct.
A photograph or image of something that would depict potentially inappropriate conduct of somebody, not the defendant, but of somebody else, something like that. Is that right?
That's correct, Your Honor. So the people will be withdrawing that notice on that particular piece of evidence, but not the previous other acts notice that was filed.
Correct.
Okay.
Right.
All right.
That's a point worth making.
Okay. Copy that. Therefore, the motion filed by the defense is moot. I do not need to issue any ruling because it's withdrawn. Based upon the communication between the parties and moving forward, I wouldn't accept an amendment to add to the witness list because we've already dealt with it, at least for that point. All right. Was there any other? You asked for an amendment for witnesses and exhibits, Mr. Harrison. Was it just for that subject?
To add that expert to refute that particular point.
Got it.
I don't have any intention of calling him. So again, the request, everything else is likewise moot, I believe.
All right, thank you very much. All right. See you all in a couple of weeks.
Okay. Thank you.
Thank you.
All right, folks, our next case this morning is People of the State of Michigan versus Juan Dion Portier. There are two file numbers here. File numbers are 25-14129 FH and 25-14130 FH. Appearances from counsel, please.
Good morning, Your Honor. Thomas Yeti, appearing on behalf of the people of the state of Michigan as Special Assistant Attorney General.
Thank you.
Robert Hartzell for Mr. Juan Fortier, who joins me to my left.
Thank you. Here today for some final pre-trial conferences. I did not speak with counsel in chambers. I was, however, handed an advice of rights, so that leads me to believe that there's going to be some kind of resolution today. Counsel.
Thank you, Your Honor. In file 25-14129 FH, I anticipate that Mr. Fortier will be entering a plea of guilty to 3 counts as charged with a sentencing agreement for a 11-month delay of sentence. And if during that period of delay he reduces the arrears owed to $4,000 or less, a conviction will enter for 1 count of attempt child support failure to pay. Also during that period, he must make payments as ordered.
The judge laid everything out clearly. 6 felony charges, 2 separate cases, and years of unpaid child support. But instead of immediate punishment, the court offered something rare: time. 1 year to make things right, to pay what was owed, and to prove responsibility. Fail to do that, and those felonies stay for life.
So when you said, after the delay, if the defendant is successful, meaning he has reduced his total arrears in file 2-9 down to $4,000 or less, which means anywhere from 0 to 4,000,
Yes,
then he'll have the right to withdraw his plea to the 3 felonies and then enter a plea to, was it 1 felony or was it to the misdemeanor version?
1 count of attempt, so the 2-year misdemeanor, I believe.
Okay.
And with 1 caveat also, Your Honor, as far as that number 0, if he reduces the amount to 0, the conviction will enter for 1 count of disorderly person.
Okay. And so what's happening with the other file? The other file will be dismissed or?
No, in file 25-14130-FH, likewise, Mr. Fortier will enter a plea of guilty as charged to the 3 counts. In that file, there is an agreement for an 11-month delay of sentence as well, with the target number being to reduce arrears to 5,000 or less, while making monthly payments as ordered. And if he does such, the charge of 1 count of attempt will enter. Also, as in the other file, if Mr. Fortier is able to reduce the arrears to 0 during the term of delay, 1 count of disorderly person will enter.
Mr. Hartel, there's a lot there. Tell me, do you agree?
All of that is accurate, Your Honor, on all parts.
All right, thank you. All right, Mr. Fortier, is that how you wish to resolve these 2 files today?
Yes.
All right, you may remain seated. Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. All right, instead of going over these date ranges, I'm just gonna ask, are you on probation, parole at this time? All right, do you have any prior, are you on bond at this time?
I believe.
I'm sorry, besides these files,
No.
The reason for asking that is if you were on probation when these occurred, you could have a probation violation. Same thing if you were on parole, or if you had a bond and you were on bond for a felony and you got sentenced. I don't think it's applying here, then there would be what's called consecutive sentencing, but with you answering that question, I don't have to go down all that, even though I just did. Oh, well. All right, so we're going to talk about these 2 files, sir, and I'm going to talk about them one at a time. Well, let's see here. Actually, no, I can talk about them all at the same time because they're all the same thing. In both these files, 14129 and 14130. In each file, you are charged with felony non-support. Each one of them includes 3 counts. Each one of those 3 counts would be a felony, punishable by up to 4 years and or up to $2,000. So in total, you have 3 counts of failure to pay child support, each one of them covering a different period of time involving a different child. And each one of these counts, I'm sorry, in each of these files, there are 3 counts, each of again a felony, failure to pay child support, punishable by up to 4 years and or $2,000. I'm told you're going to plead guilty to all of these. Then, if you do, and I accept that plea, then there's an agreement for sentencing. Now, this sentencing agreement is, and we haven't talked about this word yet, but it's called Killebrew agreement. Killebrew is just the name of an appellate case in the state of Michigan. It's kind of like how we used the Miranda name from Miranda versus Arizona back from the 60s to talk about Miranda rights. Well, this is a Killebrew agreement. Now, what does that mean? We also in Michigan have something called Cobb's agreements, again, from a case called People versus Cobb's, which I do not do. Like, that's where you and the prosecutor and I would agree right now as to exactly what the sentence would be. I don't do them because I don't know anything about the defendant. Right? I don't have any reason to think there's anything bad. I've never seen you before, but let's just say, for instance, when I come back for sentencing, if I might be shocked to find out that you are wanted all over the world for, I don't know, whatever. So then I feel bad because I'm stuck with a Cobb's agreement and I didn't know anything about the defendant when I agreed. So I don't do Cobb's agreements. This is a killer agreement, which is an agreement between you and the prosecutor. And if I don't go along with it, next time we come back, you have the right to withdraw your plea. I'd have to dismiss the convictions, and then you would be back to this very stage. Does that make sense?
Yes.
I'm not saying I won't go along with it, but you just need to make sure you understand what's going on. All right, now the agreements are in file 129 and file 130, almost the same except for the dollar value. In the first file, 129, you'll be placed upon a delay of sentence. Now, a delay of sentence is not probation, but it actually has a lot of terms that are almost identical. And that probation or that delay is up to 1 year. We generally say up to 11 months, but I don't lose jurisdiction even if it's 1 year and 3 days. I still can bring it back. Point is over that year, if you comply with their agreements, you get a couple big benefits. So the first portion, in file 130, if you pay that down, your arrears in that child support case, and at least when this case began, I don't need to know the amounts yet, but at least when this file began, you owed $7,538. And the other file, 130, you owed $9,748 plus some change. So in 130, if you get that value down to $4,000 or less, and you keep making all your other monthly child support payments, you'll have the right to come back to this court, withdraw your plea, and then plead to an additional count 4 of attempt to fail to pay child support. That goes down to a 2-year felony instead of a 1 year, instead of a 4 year, sorry. Then if you pay it down to 0, then you get to withdraw your pleas to all felonies and enter a plea of, they call it disorderly person. We have a statute in Michigan that says disorderly person, but it also includes a whole bunch of other things, including failing to care for a child. It's a misdemeanor punishable by up to 93 days and or $500. The same policy or same terms apply in the other file. Delay for up to a year, really it's up to 11 months, but up to a year. If you get your arrears down to $5,000 or less, and you continue to make all your monthly payments, you can withdraw your plea to the 3 felonies, reduce it down to an attempt failure to pay, which is a 2-year felony. And if you pay it all the way down to 0 and keep doing your monthly payments, then you have the right to withdraw, and there wouldn't be any felonies. There would just be a 93-day misdemeanor. Does that make sense?
Yes.
All right, good. So both files down to you're pleading as charged to 3 over a year. If you pay those things down to $4,000 or less, or $5,000 or less, and you make your monthly payments, you can come back and ask to withdraw your plea and enter a different plea from 6 4-year felonies down to 2 2-year felonies. If you get them all down to 0 and you pay your monthly payments, you have the right to have them reduced down to 2 misdemeanors punishable by no more than 93 days. I'm going to trust that Mr. Hartel has talked to you about the presumptions of no jail and stuff like that. Sir, is that how you wish to handle it?
Yes.
All right. For you, disregard. Now, by entering a plea of guilty, you're going to be given up certain rights. That includes the right to try by a jury, the right to try without a jury. If you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have a silence used against you, and the right to testify if you choose to testify. Mr. Fortier, do you understand those rights?
Yes,
And again, do you understand that if you enter a plea of guilty, you'll be forever waiving those rights as they apply to this case?
yes,
Additionally, any appeal, conviction and sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be available if you were convicted at a trial. You'll also be given up the right to claim the plea was a result of any promise, threat, or inducement not told me today on the record. Mr. Fortier, have there been any other promises, threats, or coercions to get you to plead guilty that we haven't talked about?
no,
You get to plead of your own free choice.
yes,
Has anyone made any promises to you as to exactly what a sentence would be?
no,
As to the, in each of the two files, as to each of the three counts, as they are alleged, how do you plead?
guilty.
Or the court can accept that plea, I need you to tell me what it is that you did that makes you guilty for that, those crimes. Now, in file 129, it appears to deal with an individual whose name is Jamie Sue Fortier. Who is that?
My ex-wife.
And did you have a child with that ex-wife? One or more? All right. And were you ordered to pay child support?
Yes,
And during there are a couple periods listed here on this felony information. Count one is between September 1st of 2022 and January 31st, 2023. Did you fail to make payments to your wife during some of that, or your ex-wife during that period?
yes,
Second count between August 1st of 2023 and August 31st of 2024. Again, did you fail to make all your payments to your ex-wife?
yes,
And as to count three, for a time period of September 1st of 2024 and March 31st of 2025, did you again fail to make payments to your ex-wife for that child care?
yes.
Thank you. Also, now looking at file 130, who is Misty Joe Shippers?
Joy Shepherd.
Shepherd, sorry.
That is the mother of my first and third boy.
All right, thank you. As to that case, in count one, covering a date range of September 1st of 2022 through January 31st of 2023, did you fail to pay Ms. Shepherd's all the child support?
Yes,
In count, or for count two, regarding a time period of August 1st, 2023 through August 31st of 2024. Again, did you fail to make those payments or all the payments to Ms. Shepherd's?
yes,
And in count three, beginning on September 1st, 2024 through March 31st, 2025, did you fail to make all the necessary payments to Ms. Shepherd's?
yes,
And in each file, you were ordered to pay Ms. Shepherd's and Ms. Fortier child support from a courtroom. A court gave that order. Or you entered in a written agreement that was approved by the court.
it was a court order.
All right, thank you. Sir, do you believe he's provided a factual basis?
I do.
Mr. Hartel?
As do I, Your Honor.
Sir, do you believe I've complied with all the court rules, 6.302?
It appears the court has, Your Honor.
Good. And Mr. Hartel?
Agreed.
And sir, do you believe, are you aware of any other promises, threats, or inducements?
I am not.
Mr. Hartel?
Nor am I, Your Honor.
Thank you. All right. The court agrees, finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements to demonstrate proof for the 6 counts, 3 counts in each file. Therefore, the defendant is found guilty of all 6 of those counts.
This wasn't mercy, it was accountability. The court gave him a choice most defendants never get. Pay down the arrears, follow every rule, and walk away with reduced charges. Ignore the opportunity, and 6 felonies become permanent. In that courtroom, the message was simple: fix it now or face the consequences.
Fortier will be back here in about a month. Between now and then, an agent from the Michigan Department of Corrections is going to prepare a pre-sentence investigation report. That report will describe the offense, the pretrial agreement, any statements, information you make or provide, as well as information if the victims choose to make a statement. It will also talk about any prior convictions you have, if you have any, and will tell me how you've done on probation, parole, or bond, if that's ever been something in your past. It will also make a recommendation as to sentencing. Please keep in mind it's merely a recommendation as it is the court alone that makes the determination of the sentence. Plus, next time, if I don't go along with the pretrial agreement, you'll have your right to withdraw that plea, as I told you earlier. Now, when you leave this courtroom, you have to help us prepare this report that has done, which is done in the state of Michigan, anytime someone's convicted of a felony. You're gonna take the elevator, go all the way downstairs to the probation and parole office. So if you take that elevator all the way down to the bottom floor, step out, do a button hook to the right. Straight ahead of you will be a door. Go through that door. Their office is the last one on the left. You can't miss it. There's only 3 windows there. You can just stand in the hallway and say, where do I go? And they'll tell you where to go. They're gonna give you a packet. You're gonna complete it, turn it in. They're gonna schedule you for an interview. You have the right to have Mr. Hartel present. Next, Mr. Hartel needs to make sure he can get a hold of you, so you have to stay in contact with him. He's gonna need to tell you when you need to come back to court, and he's gonna have to sit down and go over that report with you prior to coming back to court, as each side has the right to come to this court and request corrections or amendments to the report. Do you understand?
Yes.
Any questions about what we've done? All right, let's start making those payments. Anything further?
No, thank you, Your Honor.
Mr. Hartel?
No, thank you.
Bond hereby continues. Your excuse, we're adjourned.
Thank you, Your Honor.
Thank you.
Counsel.